All right. So, if you're gonna write stuff down, here's some things I want you to write down right quick before we get started looking at this. And here's how we're gonna do this. I'm gonna give you some things to write down. I'm gonna give you some opening points, and then I'm gonna read, and you're gonna follow along through this overview. The vast majority of questions will be answered right there. If there are other questions, then we'll talk about them afterwards, okay? So that's what's going on. All right, so the first thing I want you to know is that when you get through this opinion, what you're going to find out is that neither the conservatives who are excited about the fact that Roe versus Wade was overturned, nor the liberals who are hysteric about the fact that Roe v. Wade was overturned actually got what they were looking for. This judgment is not nearly as revolutionary as people think it is. It is important. It will have a huge impact, but it's not going to have the impact that a lot of people in the media are trying to make it sound like it's going to have. So that's one thing to keep in mind. All right, now, second thing. There are three aspects of the abortion conversation and dialogue that are that have to be addressed, and the Supreme Court only actually addresses one of those. So the first is the biology question. What is life and when does it begin? Right? That's a huge question. And it's very much a specific, or the abortion issue is very much specifically grounded in that question. What is a life? Is a life before a baby is born? We as Christians refer to it as a baby, but is that a baby or a clump of cells? Is that clump of cells a human life or not a human life? Is it a human life that deserves the protections of a human life, or is it a potential life? One of the previous cases that's overturned, Planned Parenthood of Southwestern PA and Casey referred to it as potential life. That's a big difference from actual life. So it's a biological question, and one that we have to ascertain. Is there one body in the question of abortion, or is there two bodies in the question of abortion? And as we read through this, what you're going to notice is that this doesn't actually even try and tackle that question. The second question with the abortion conversation that's really important is the moral philosophy question, the philosophical question of what is life? Like, what do we actually consider life to be? What is consciousness? When does it have value? How do we determine value? How do we decide value? Also, a core question to the abortion conversation, because if someone is alive and breathing but they're brain dead, there are those whose philosophy about what life is would determine that that is not life, and therefore they don't have a right to life because they don't have life. And there are those, usually traditionally Christians, who would say no, as long as there's breath in the body, they're alive and they have a right to live, and that life can't be terminated. Those are philosophical questions and often religious questions. And as we go through this overview, you will again notice that those are questions that this doesn't even cover. The third is the issue of constitutional law, what Justice Alito here will refer to as ordered liberty. What is ordered liberty? What does it mean to have personal autonomy and communal responsibility? Where are those lines drawn? You might say the question of who determines your rights and who protects your rights, and how does all that work? And what you will find as we go through this is that that is at the core of what the justices are actually concerned with. So, if you buckle in, we'll read. If you have a question as we're going through about what something means, you can raise your hand if you want, and if I look up, I'll acknowledge that. But otherwise, make a note of it, and we'll come back to it. All right. There's a lot of legalese in here that I'm going to kind of skip over that isn't necessary for the reading part of it. But so anyway, all right. So this is the overview of the determination. It starts with right there in the middle of the page, argued December 1st, 2021, decided June 24th, 2022. So it was not officially in the record until June 24th. Mississippi's Gestational Age Act provides that except in a medical emergency or in the case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being. If the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. So you catch that? Not a potential life. They already, in Mississippi, refer to the baby as an unborn human being. But the cutoff point that they had put in was 15 weeks. So their law did not get rid of abortion entirely. It just said no later than 15 weeks. That's important. And it left the exemption for medical emergency and severe fetal abnormality. Respondents, those who said, hey, we don't like this, Jackson Women's Health Organization, an abortion clinic, and one of its doctors challenged the act in federal court, alleging that it violated the court's precedents establishing a constitutional right to abortion. In particular, Roe versus Wade and Planned Parenthood of Southeastern PA versus Casey. The district court granted summary judgment in favor of the respondents and permanently enjoined enforcement of the act, reasoning that Mississippi's 15-week restriction on abortion violates this court's cases forbidding states to ban abortion pre-viability. The Fifth Circuit affirmed before this court practitioners defend the act on the grounds that Roe and Casey were wrongly decided and that the act is constitutional because it satisfies rational basis review. Okay, so clarify that right quick. The people, the Jackson Women's Health Organization were saying that Mississippi's Gestational Age Act violated the Supreme Court's precedent, which established a constitutional right to abortion. And notice the language. What they're saying is the Supreme Court has already said abortion is a constitutional right based on their understanding of Roe versus Wade and Casey versus Pennsylvania. And what Mississippi argued in reverse, what they counter-argued was that in fact the Mississippi Act was constitutional because it satisfies rational basis review, which they're going to get into in a few minutes and explain what they mean by that, and that Roe and Casey were wrongly decided. So their argument was Casey and Roe versus Wade and Casey versus Pennsylvania were not correctly decided in the first place. And so that's what they're about to get into. And so what the discussion or what the decision of the Supreme Court was, you see where it says held, is that the Constitution does not confer a right to abortion. It's really big. Hear the phrasing. The Constitution of the United States does not confer a right to abortion. It does not say there is no right to an abortion. It says that what they found was the Constitution does not confer a right to abortion. Do you hear the difference there? Because that's important. The Constitution does not confer a right to abortion. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people and to their elected representatives. So who gets to decide about abortion now? the people and their representatives. This is really big because the way our system is set up, the Constitution outlines the laws or outlines the rights that no one's allowed to mess with. It's like Second Amendment stuff, right? The ability to bear arms is not to be infringed upon. The court just found the other day that New York City not being willing to give permits to people to open carry was actually a violation of their Second Amendment right, because plain text of the Constitution is the right to bear arms. So what they're saying is you can't find abortion as a constitutional right. But that doesn't make it not a right. It makes it not in the Constitution. You follow that difference? The language of these things are extremely important. The authority to decide about abortion, to regulate abortion, is returned to the people and their elected representatives. The critical question is whether the Constitution, properly understood, confers the right to obtain an abortion. Casey's majority opinion or controlling opinion skipped over that question and reaffirmed Roe solely on the basis of stare decisis. Stare decisis is Latin. It means that it is a decision that was already made and it's going to be upheld. It's what they call a doctrine of the court. It is not in the Constitution. It's just a principle of how the court operates. And they get into explaining that as you go further through this. And they talk about the idea of what stare decisis is and how it should work. And it says right there in the overview, the next thing, a proper application of stare decisis, however, requires an assessment of the strength of the grounds on which Roe was based. The court, therefore, turns to the question that Casey did not consider. So what he's saying is, even though we overturned Roe versus Wade and Casey versus Pennsylvania, what you need to understand is that when Casey was decided, they didn't actually look at the basis for Roe versus Wade to decide if it was something that should be upheld or not. They simply said, because it's already decided, we're going to agree to keep it. And so, when they're overturning these two rulings, not laws, very important distinction, right? The Supreme Court doesn't make law. The Supreme Court makes rulings on laws. So when they're overturning the rulings previous, what he's saying is there needed to be a review of the basis of those cases, and that basis didn't happen, or that review didn't happen. The court therefore turns to the question that Casey plurality did not consider. First, the court reviews the standard that the court's cases have used to determine whether the 14th Amendment reference to liberty protects a particular right. The Constitution makes no express reference to a right to obtain an abortion, but several constitutional provisions have been offered as potential homes for an implicit constitutional right. In other words, there are several of the amendments that people have made the argument should protect a right to abortion. But several constitutional provisions have been offered as homes for an implicit constitutional right. Roe held that the abortion right is part of the right to privacy, springing from the 1st, 4th, 5th, 9th, and 14th Amendments. That seems pretty strong, right? Just on a direct reading. So when you hear people say, well, no, but abortion is a constitutional right, what you need to understand is that what they're drawing from is Roe's decision, the Roe versus Wade decision, which couched the right to an abortion in the right to privacy stemming from the 1st, 4th, 5th, 9th, and 14th Amendments. It is really important, if you're going to argue with people about the position they take, to understand the position they take before you argue, right? Unfortunately, if you remember the first thing I said, Most Christians have focused entirely on biology and philosophy with people who weren't really concerned about biology and philosophy. The reason why this case went through the way it did is because it's the first time the pro-life movement actually focused on the law. So, Casey Court grounded its decision solely on the theory that the right to obtain an abortion is part of the liberty protected by the 14th Amendment's Due Process Clause. Others have suggested that support can be found in the 14th Amendment's Equal Protection Clause, but that theory is squarely foreclosed by the court's precedents, which established that the state's regulation of abortion is not a sex-based classification and is thus not subject to the heightened scrutiny that applies to such classifications. And you'll look and you'll see where it gives you several different italics things. Those are previous court cases that the majority are referencing, which establish this distinction. What he's saying is you can't argue that abortion is sex-based for the purpose of making it a constitutional right when you've already argued that it's not sex-based for other purposes. If the court has established that it's not sex-based for other purposes, but never actually established where it is constitutional. Anyway, rather, regulations and prohibitions of abortion are governed by the same standard of review as other health and safety measures. Next, the court examines whether the right to obtain an abortion is rooted in the nation's history and tradition, whether it is an essential component of ordered liberty. The court finds that the right to an abortion is not deeply rooted in the nation's history and tradition. The underlying theory on which Casey rested, that the 14th Amendment's Due Process Clause provides substantive as well as procedural protection for liberty, has long been controversial. In other words, people don't agree on it. The court's decisions have held that the Due Process Clause protects two categories of substantive rights: those rights guaranteed by the first 8 amendments to the Constitution, and those rights deemed fundamental that are not mentioned anywhere in the Constitution. In deciding whether a right falls into either of these categories, the question is whether the right is deeply rooted in our history and tradition, and whether it is essential to the nation's scheme of ordered liberty. And then he gives you a reference for where that principle has been derived. The term liberty alone provides little guidance. Thus, historical inquiries are essential when the court is asked to recognize a new component of the liberty interest protected by the Due Process Clause. In interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about liberty that Americans should enjoy. For this reason, the court has been reluctant to recognize rights that are not mentioned in the Constitution. There we come back to this issue of constitutional law. Guided by the history and tradition that map the essential components of the nation's concept of order liberty. So looking at history and seeing what we've always said makes us free. The court finds that the 14th Amendment clearly does not protect the right to an abortion. This is really important. This is history that nobody talks about anymore. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. No state constitutional provision had recognized such a right. Until a few years before Roe, no federal or state court had recognized such a right, nor had any scholarly treatise. Indeed, abortion had long been a crime in every single state. At common law, abortion was considered criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences in all stages. American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions, and by the time the 14th Amendment was adopted, 3/4 of the states had made abortion a crime at any stage of pregnancy. This consensus endured until the day Roe was decided. Now notice what he's saying. The consensus of the people through their representatives making law was that abortion was wrong. until the court decided that the laws that had been made were wrong and overturned the laws of the people. That's what he's saying. History. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. Respondents' argument that this history does not matter flies in the face of the standard the court has applied in determining whether an asserted right that is nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment. What he's saying is they have, in times gone by, and he'll mention a few, but the Obergefell case where they made same-sex marriage a constitutional thing, right? What he's saying is the courts have in the past found things that they felt were in fact protected by the Constitution based on our historic culture and tradition and how we understood what liberty was, maybe not necessarily those social issues, but liberty, has in the past found things that were new. However, this issue, abortion, is not really new. It's an issue that the people had already spoken on, is what he's saying. The Solicitor General repeats Roe's claim that it is doubtful abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. But the great common law authorities, Bracton, Coke, Hale, Blackstone, all wrote that a post-quickening abortion was a crime. Moreover, many authorities have asserted that even a pre-quickening abortion was unlawful, and that as a result, an abortionist was guilty of murder if the woman died from the attempt. The Solicitor General suggests that history supports an abortion right because of the common law's failure to criminalize abortion before quickening, but the insistence on quickening was not universal. And regardless, the fact that many states in the late 18th and early 19th century did not criminalize pre-quickening abortions does not mean that anyone thought the states lacked the authority to do so. So what he's saying is the Solicitor General is ignoring history. Instead of seriously pressing the argument that an abortion right itself has deep roots, this is important. Supporters of Roe and Casey contend that the abortion right is an integral part of a broader entrenched right. That Roe termed this as a right to privacy, and Casey described it as the freedom to make intimate and personal choices that are central to personal dignity and autonomy. Man, I love that language. I think about that every time somebody tells me that they want me to do something with my kids. And I'm like, screw you, they're my kids. Do what I want. Right? I like right to privacy. The freedom to make intimate and personal choices that are central to personal dignity and autonomy. Heck yeah. And that's what they argued. They said, well, abortion should sit in that category. Think about that. Right? Because as much as it got real popular here for a while there, when the vaccine thing was big, for people to go, ha ha ha, my body, my choice. Not now, is it? Ha ha ha. Yeah, you wanted my body, my choice, but now you want me to take your vaccine. Well, it's my body, my choice. Ha ha ha. Here's the problem with that. When it's no longer about the vaccine and we're back to talking about abortion, we're still having the same fight. Right? Still my body, my choice. And that's what they're saying. Those who press the argument that abortion is a part of an integral part to a broader entrenched right termed it as a right to privacy, and the freedom to make intimate and personal choices, and central to personal dignity and autonomy. Ordered liberty. This is the response of the majority to that argument, which is a part of the overturning of Roe v. Wade. Ordered liberty sets limits and defines the boundary between competing interests. That should scare you, just for the record. We like ordered liberty as long as ordered liberty goes our way. Ordered liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they term potential life. But the people of the various states may evaluate those interests differently. The nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. What he's saying is this is not something courts get to decide. Ordered liberty is a conversation for communities to have amongst themselves and for their elected representatives to make decisions about, which end up in law. The nation's historic understanding of, I just read that. Finally, the court considers whether the right to obtain an abortion is a part of a broader entrenched right that is supported by other precedents. The court concludes the right to obtain an abortion cannot be justified as a component of such rights, or of such a right. Attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. That right there is a statement about philosophy of life. He's saying we ain't having the argument about philosophy of life. That's too much. That's not for the court. Those criteria at a high level of generality could license fundamental rights to illicit drug use, prostitution, and such. And all the libertarians went, yeah. What sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey rely is something that both of those decisions acknowledged. Abortion is fundamentally different. I just added fundamentally, I'm sorry. Abortion is different because it destroys what Roe termed potential life and what the law challenged in this case, the Mississippi law, calls the unborn human being. None of the other decisions cited by Roe and Casey involved the critical moral question posed by abortion. Accordingly, those cases do not support the right to obtain an abortion, and the court's conclusion that the Constitution does not confer such a right does not undermine them in any way. So what he's saying is those other laws, right, those other laws, while they deal with the issue of privacy, yes, they don't deal with an issue that has a moral question like abortion. Again, notice, what are they not dealing with? The moral question. He's saying those other laws don't deal with the moral question about murder, so they are qualitatively different. So to use them to justify a decision about Roe versus Wade or Casey versus Pennsylvania doesn't really work because there's a qualitative difference that must be taken into consideration. This does not mean that those laws are wrong. That's what he's saying. This doesn't undermine those laws in any way. It doesn't mean those laws are wrong. And it doesn't mean that abortion is a settled issue. It just means that using those laws to justify making a decision about abortion law doesn't work. Doesn't correspond. The doctrine of stare decisis does not counsel continued acceptance of Roe Casey. Stare decisis plays an important role and protects the interests of those who have taken action in reliance on a past decision. It reduces incentives for challenging settled precedents, saving parties and courts the expense of endless relitigation. It contributes to the actual and perceived integrity of the judicial process, and it restrains judicial hubris by respecting the judgment of those who grappled with important questions in the past. Great, man. Oh, that is good stuff. The restraint of judicial hubris. What a great phrase. But stare decisis is not an inexorable command. In other words, it's not one of the 10 commandments. It's a guiding principle. It is itself not constitutional law. That's a big distinction. It's like the difference between interior decorating in a church and teaching the scripture in a church. Like teaching the scripture, there's a pretty hard line about that. Here's how you do it. If you guys want to change the carpet, a guiding principle is don't change the carpet to a color that doesn't match anything that's already here, right? That would be dumb. Stare decisis is a guiding principle. It is not one of the 10 commandments. It's not in the Constitution. It is at its weakest when the court interprets the Constitution. Stare decisis is at its weakest when the court interprets the Constitution. That's a huge statement because it goes back to what we're talking about. Some of the court's most important constitutional decisions have, in fact, overruled prior precedents. Brown versus Board of Education, you guys may remember that one, which overruled the infamous decision in Plessy versus Ferguson. The court's cases have identified factors that should be considered when deciding when a precedent should be overruled. But you guys didn't know that they had principles for their principles. 5 factors discussed below weigh strongly in favor of overruling Roe and Casey. The nature of the court's error. Like the infamous decision in Plessy versus Ferguson, Roe was also egregiously wrong and on a collision course with the Constitution from the day it was decided. Casey perpetuated its errors, calling both sides of the national controversy to resolve their debate, and in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. The court short-circuited the democratic process by closing it to the large number of Americans who disagreed with Roe. So what he's saying is, when the court abjugates the people's ability to have their representatives make laws, there's a problem. The quality of the reasoning. Without any grounding in the constitutional text, history, or precedent, Roe imposed on the entire country a detailed set of rules for pregnancy divided into trimesters, much like those that one might expect to find in a statute or regulation. Roe's failure even to note the overwhelming consensus of state laws in effect in 1868 is striking, and what is said about the common law was simply wrong. Then, after surveying history and opinion, spent many paragraphs conducting the sort of fact-finding that might be undertaken by a legislative committee, and did not explain why the sources on which it relied shed light on the meaning of the Constitution. As to precedent, citing a broad array of cases, the court found support for a constitutional right of personal privacy, but Roe conflated that right, the right to shield information from disclosure, and the right to make and implement important personal decisions without government interference. None of these decisions involved what is distinctive about abortion, its effect on what Roe termed potential life. When the court summarized the basis for the scheme it imposed on the country, it asserted that its rules were consistent with, among other things, the relative weights of the respective interests involved and the demands of the profound problems of the present day. These are precisely the sort of considerations that legislative bodies take into account when they draw lines that accommodate competing interests. The scheme Roe produced looked like legislation, and the court provided the sort of explanation that might be expected from a legislative body. An even more glaring deficiency was Roe's failure to justify the critical distinction it drew between pre- and post-viability abortions. The arbitrary viability line, which Casey termed Roe's central rule, has not found much support among philosophers and ethicists who have attempted to justify a right to abortion. The most obvious problem with any such argument is that the validity has changed over time and is heavily dependent on other factors, such as medical advances and the availability of quality medical care that have nothing to do with the characteristics of a fetus. When Casey revisited Roe almost 20 years later, it affirmed Roe's central holding, but pointedly refrained from endorsing most of its reasoning. The court abandoned any reliance on a privacy right and instead grounded the abortion right entirely on the 14th Amendment's due process clause. The controlling opinion criticized and rejected Roe's trimester scheme and substituted a new and obscure undue burden test. Casey, in short, either refused to reaffirm or rejected important aspects of Roe's analysis, failed to remedy glaring deficiencies in Roe's reasoning, endorsed what it termed Roe's central holding, while suggesting the majority might not have thought that it was correct, provided no new support for the abortion right other than Roe's status as precedent, and imposed a new test with no firm grounding in constitutional text, history, or precedent. I bet that's stuff you didn't know about, is it? What he's saying is that the court's reasoning was not only faulty, but that they did the job that a legislative body is supposed to do, not what a court is supposed to do. The courts look at the Constitution and they look at the law that exists and they decide if things are happening the way the law says they're supposed to happen. The court's not supposed to make laws. 3, workability. Deciding whether a precedent should be overruled depends in part on whether the rule it imposes is workable. That is, whether it can be understood and applied in a consistent and predictable manner. Casey's undue burden test has scored poorly on the workability scale. The Casey plurality tried to put meaning into the undue burden test by setting out 3 subsidiary rules, but these rules created their own problems, and the difficulty of applying Casey's new rules surfaced in that very case. The experience of the Court of Appeals provides further evidence that Casey's line between permissible and unconstitutional restrictions has proved to be impossible to draw with precision. Casey has generated a long list of circuit conflicts. Continued adherence to Casey's unworkable, undue burden test would undermine and not advance the even-handed, predictable, and consistent development of legal principles. Effect on other areas of law. Roe and Casey have led to the distortion of many important but unrelated legal doctrines, and that effect provides further support for overruling those decisions. Number 5, reliance interests. Overruling Roe and Casey will not upend concrete reliance interests like those that develop in cases involving property and contract rights. In Casey, the controlling opinion conceded that traditional reliance interests were not implicated because getting an abortion is generally unplanned activity, and reproductive planning could take virtually immediate account of any sudden restoration of state authority to ban abortions. Instead, the opinion perceived a more intangible form of reliance, namely that people had organized intimate relationships and made choices that defined their views of themselves and their places in society in reliance on the availability of abortion in the event that contraception should fail, and that the ability of a woman to participate equally in the economy and social life of the nation has been facilitated by their ability to control their reproductive lives. So notice what he's saying. Traditionally, the idea of interests, of facilitated interests, was something that had to be stable and long-term, like property rights. When Casey was decided, they determined that the facilitated interests were not long-term interests like that. They even acknowledged that getting an abortion or not getting an abortion based on the state was not something that really impacted long-term, because you could make those choices when you needed to. But rather, the sociological dynamic of the fact that people liked having sex and not having to worry about if sex produced a baby. And that people wanted to go to work, women wanted to be able to go to work and pursue careers, and if they got pregnant and they had to have a baby, they might not be able to pursue a career. And so the sociological fabric of America had shifted enough that because of Roe v. Wade, that to overturn Roe v. Wade would have been wrong because it would have upset our sociological fabric. That was Casey's basis of saying we can't overturn this. It's too important to the way we conduct ourselves now. The contending sides in this case make impassioned and conflicting arguments about the effects of the abortion right on the lives of women as well as the status of the fetus. The Casey plurality's speculative attempt to weigh the relative importance of the interests of the fetus and the mother represent a departure from the original constitutional proposition that courts do not substitute their social and economic beliefs for the judgment of legislative bodies. The Solicitor General suggests that overruling Roe and Casey would threaten the protection of other rights under the Due Process Clause. The court emphasizes that this decision concerns the constitutional right to an abortion and no other right. It's important because one of the things the news keeps saying is that now every right that the court has decided in the last 40 years could be overturned. In the ruling, they're saying, no, this is only about abortion. He will go on to say, stare decisis requires that every single thing that comes before the court gets its own judicial review. So if they use this to overturn something else, they would be in error in their own processes. That's his argument. Casey identified another concern, namely the danger that the public will perceive a decision overruling a controversial watershed decision, such as Roe, as influenced by political considerations or public opinion, like people coming to your house and throwing rocks at your windows or trying to kidnap you and kill you. They, influenced by public opinion. But the court cannot allow its decisions to be affected by such extraneous concerns. A precedent of this court is subject to the usual principles of stare decisis, under which adherence to precedent is the norm but not the inexorable command. If the rule were otherwise, erroneous decisions like Plessy would still be the law. The court's job is to interpret the law, applying long-standing principles of stare decisis, and decide this case accordingly. Under the court's precedents, rational basis review is the appropriate standard to apply when state abortion regulations undergo constitutional challenge. Given that procuring an abortion is not a fundamental constitutional right, it follows that the state may regulate abortion for legitimate reasons, and when such regulations are challenged under the Constitution, courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. That applies even when the laws at issue concern matters of great social significance and moral substance. A law regulating abortion, like other health and welfare laws, is entitled to strong presumption of validity. It must be sustained if there is a rational basis on which the legislature could have thought that it would serve legitimate state interests. Yay! Mississippi's Gestational Age Act is supported by the Mississippi legislature's specific findings, which include the state's asserted interest in protecting the life of the unborn. These legitimate interests provide a rational basis for the Gestational Age Act, and it follows that respondents' constitutional challenge must fail. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. The court overrules those decisions and returns that authority to the people and their elected representatives. Now, again, not nearly as exciting as some people think it is, and not nearly as bad as some people think it is. Because here's the thing. Did you notice It says that the second to last paragraph says a law regulating abortion like other health and welfare laws is entitled to strong presumption of validity. It must be sustained if there is a rational basis on which the legislature could have thought that it would serve legitimate state interests. So what that means is that every legislature in every state after this ruling now has the ability to fight this out. But make no mistake, that's exactly what happens. They will all fight this out because the legislature needs to determine a rational basis for legitimate state interests. And if they see abortion as being against the state's interests because they believe that that's a potential human life and we're losing way too many people and we need to force everybody to keep the babies that they're having, or because shockingly maybe they have a moral enlightenment moment and they're like, hey, that's a human life, and they decide not only to outlaw abortion but also to make adoption free, right? And they argue that those are legitimate things because of the science and because of the moral component and because of the fact that it has to be done, and the legislature passes that law and abortion's outlawed, then those states will have less abortion. But it also works the other way. If the legislatures fill up with people who believe that abortion is a good thing, that it serves the state interest to allow abortions because we have too many babies, that it serves the state's interests to to allow for abortions because people in lower income communities, right, if they're having babies and they can't take care of them and poverty increases, we know that where poverty increases, crime increases, just because that happens to be, entirely black communities, and we're going to forget about that part. We'll forget about the fact that Planned Parenthood targets low-income black communities. Just ignore that. Point is, if the legislature can make the argument that abortion actually serves the state's interest, and they can rationally ground that argument, then what the Supreme Court is saying is that if it serves legitimate state interests, that is also the state's right to pass those laws. It's really important. The only thing they're saying is that it's not in the U.S. Constitution. That's it. That's this whole thing. It's not in the U.S. Constitution. Now, there may be some implications to that. For instance, because it's not in the U.S. Constitution, it may be, and I don't know this, this is just speculation, I haven't had a chance to look into it, but it may be that places like Planned Parenthood, which get millions of dollars, like millions, like $500 million in federal aid, which is your taxes going to the federal government and then going to Planned Parenthood. Well, it's really not our taxes. It's actually Chinese money. But it's our money, it's our children's taxes going to Planned Parenthood every year because they're an abortion provider. Well, it may be that this decision will sever that connection. That maybe the federal government will no longer be able to fund abortion activities. But here's the thing, Planned Parenthood isn't predominantly funded by the federal government for abortion. They're predominantly funded by the federal government for women's health stuff. Even though what they do mostly is abortion, it's like 90% of their work. Actually, I think it's, let's be fair, I think it's like 66% of what they do. But they're funded predominantly by the federal government for the other women's health stuff that they supposedly do. So even if that money is cut off where abortion is concerned, it may not really affect them, and it may not all be cut off. So there may be those implications. But in general, this isn't about making a moral statement. And it's not about making a philosophical statement. And it's not about making a scientific statement. It's about making a legal statement. That's as big and as small as it is. Now there's some more stuff further in. that I could share with you, but that took longer than I expected. So I don't want to keep you all day, although I hope you ate well. But one of the things that Alito says, though, that I think is really worth remembering, and I was having this conversation just a little while ago. Justice Alito, who delivered the majority opinion, which is what this is based on, he actually starts his fleshed out, his bigger opinion, with the statement, abortion presents a profound moral issue on which Americans hold sharply conflicting views. It's important to understand that when the guy who wrote the majority opinion was writing his opinion, he understood this is not an open and shut thing. It is an issue, it is a moral issue on which Americans hold sharply conflicting views, some believing fervently that a human person comes into being at conception and that abortion ends an innocent life. Others feel just as strongly that any regulation of abortion invades a woman's right to control her own body and prevents women from achieving full equality. Still others in a third group think that abortion should be allowed under some but not all circumstances, and those within this group hold a variety of views about the particular restrictions that should be imposed. The reason why, well, fine. The reason why that's important to understand is because despite whatever Alito's personal opinion on abortion is, what he's saying is, I understand that all of you have different opinions. It's not my job to tell you what your opinion should be. It's my job to tell you what the Constitution says. That's it. That's a big deal. It's a big deal to me because the only way our country works is if we're constitutional. Without the Constitution and a representative democracy, a constitutional republic, without that, we're not the United States of America, we're something else. Which is Alito's argument against the dissent. So, as I said earlier, I have this on PDF, and I'll be glad to send it to any of you if you want to read the whole thing. But when you get to the dissent, which is that big, that's the dissent. This is Alito's actual full opinion, right? What I just read you a summary of, and that's the dissent. They're almost the same size. The dissent is well written, articulate, intelligent, and I would argue fundamentally flawed. Fundamentally flawed because it approaches this conversation not from the perspective of a constitutional republic, but from the perspective of something else. Something that we are not as a nation. And I think that's kind of telling. And Alito deals with his responses to that in the fuller fleshed out thing that he does. But there's definitely, at the heart of this disagreement, the constitutional side of it, not the moral and the philosophical and the biological and the religious stuff, but just this. There's a severe divide between how people understand the relationship of the Constitution of the United States to the American people. And so one of the other things that our education system and our media have really done an injustice to us with is that they don't talk about the fact that there are real differences of how to look at the Constitution. So the majority opinion on this issue was what we would call an originalist constitutional law decision. It was based on what the Constitution actually said and what it was intended to mean and how that applies to us now. The dissent is built off of what's known as a progressive constitution or progressive constitutional law basis, which is the same root that we get critical theory from. And it's basically the idea that whatever was written in the past, as nice as it may be, its context is the past, and in order to make sense of it and make it valuable, it must be moved forward into the present and shifted and changed and adapted. It's not stable. It's constantly changing. This is the same divide between conservative historic theology and liberal theology. Those who say the Bible's the Bible, we must understand the Bible in its context and then say, how does it apply to us now? And those who say the Bible is nice, but, I mean, really, it only means what we want it to mean in the basis of our context now. So we'll let go of the parts we don't like, and we'll throw those out, and we'll keep the parts we do like. And unfortunately, where the dissent may have been able to make better arguments, their arguments, in my opinion, fall flat for that very reason. And in Alito's opinion, and apparently the opinion of the other 6 justices who disagreed with them. So, that's my summary. What will stay? Yeah. Well, yeah, sort of. So, that, again, constitutional law, that's where you get into that really weird area. Like, when Andrew Jackson was president, right, the Native Americans in Georgia, they were trying to use, the government of Georgia was trying to use eminent domain to take the land from the Native Americans, which had been promised to them in a treaty. So the Native Americans came to the Supreme Court, and they filed a complaint with the Supreme Court and said, hey, Georgia's using eminent domain to take our land. We want you to stop them. The Supreme Court sided with the Native Americans. They said, no, the United States of America has made a treaty with you, and we need to uphold that treaty. Georgia needs to stop. It's not allowed. You need to keep your land. The problem is, in order for that ruling to work, Andrew Jackson, who was president at the time, needed to tell the military to tell Georgia to cut it out and enforce the decision of the Supreme Court. And Andrew Jackson's response was, it's the Supreme Court's decision, they can enforce it. And that's how we ended up with the Trail of Tears. The problem with the way our government is set up is that it's supposed to be checks and balances. But when those checks and balances are not, operating as they should, because instead of having civil servants, you have tyrants, then it doesn't work the way it's supposed to. So technically, yeah, the law that's on the books should be the law that's abided by until the legislation figures out a new law, and then that gets passed, both houses, and then the governor signs off on it, and then it endures any challenges to the state Supreme Court, right? The governor has to sign off on it, so if the governor doesn't like it, he can veto it. Then it goes back to the houses, and the houses can do a supermajority vote and overrule the governor's veto, all of which takes years. Many times, that process never happens because it takes so long that new people are elected, and so the will of the people kind of shifts, which is why it's so important that you, while you live in this country where you have the ability to have conversations with your neighbors and influence elections, actually have conversations with your neighbors. Otherwise, the people who have the most money win every election. The guy who's got the most commercials on TV, even if they're wrong. Or the guy who Bill Maher thinks is cool, maybe he wins. Bill Maher does a great job of making everybody else look stupid, right? Even if they're not. But that's the world we live in. But the will of the people wins if the people do what our government was designed to do and talk to each other and argue with each other and figure this stuff out. And then maybe some of you, just maybe God's going to put it on your heart and he's going to say, hey, your mind was built for this task. Go. Be a civil servant. Go get a seat at that table. But yeah, that's why it all starts here. Like rape and incest. Well, what about rape and incest? 1% of all abortions performed are rape and incest. 1%. Like, and I'm not saying that's not important. What I'm saying is it's a horrible argument. Yet that's the one that gets thrown out so much. What about a medical emergency? Well, first off, a medical emergency is a medical emergency. Technically, a medical emergency isn't an abortion. The idea that a medical emergency and abortion are the same thing has been conflagrated by people who have not been precise with their language. When you look at law, law does not consider a medical emergency and an abortion the same procedure. Now, morally and religion-wise, there have been some problems conflagrating the two as well. There have been churches that have taught that anytime a pregnancy ends, it's an evil thing, which has made it really difficult for women who have struggled through miscarriages or other medical issues to find the support they needed from their churches. But that's, my eye'll start twitching. That is a different problem. But the actual distinction is written into law. Like there's already a distinction there. So again, that's not actually an issue that most people are ever going to deal with. But that media, man, they'll get you. And we need to take that into account, especially our young people. Especially our young people. Man, think about that. You got kids who aren't even hitting puberty yet, who have strong opinions about this issue. Where'd they get those opinions? Did they read this? I'm going to guess that there's not many 10-year-olds out there who read this. Just a guess. You're not going to win them over or make them, bring them to the side of truth by saying, well, you're just 10 and you're an idiot. Right? Anyway. Yeah. Which is within their rights as a company and within the rights of individuals. If you live in a state that has restricted abortion or outlawed it entirely, you have every right to go to another state. Again, this goes back to the state law aspect of the way our government was actually set up. Every state was, in a sense, its own autonomous thing. It's very similar to church, right? I tell you all the time. How many times have I said, look, there are a lot of different ways you can understand the Bible, but you come to my church, so you get to hear me preach, right? If you don't like it, that's fine. No skin off my back. There's 50 other churches. Go find one you like. I mean, you may end up somewhere that I think's crazy, but that's okay, because I'm here, and you're there, and it's fine. I'm not your dad, right? Jesus has you under control. God will take care of you. It'll be fine. We can disagree. Well, that's the way our government was set up. It's like if New York wants to say that you can kill a baby in the 14th trimester, that's New York. But we're not gonna, because we're a little more conservative than that. But Texas is like, yeah, no. And if you want to go to another state, go to another state. And if you want to move to another state, move to another state. The reality is that this overturning Roe v. Wade will actually impact almost no one. The red states, where most abortions don't happen anyway, because the will of the majority of the people is reflective of their value system, which is that abortion isn't a good thing. They don't have a lot of abortions that take place in the deeper red states anyway. And in the blue states where the majority of abortions are taking place, they already have laws on the books that protect abortion. So this ruling isn't going to shift that at all. There's going to be a handful of people who live in states where it becomes harder to get an abortion, and there will be some people, don't get me wrong, I'm not saying nobody, but there will be some people who will be impacted by this, but not nearly as many as people think. With the exception, and this is important, with the exception of the fact that as the media builds hysteria into the national conversation, more and more people will respond to that hysteria. And in response to that hysteria, you'll have problems. Depression and anxiety are at an all-time high amongst young people, right? Like 30 and under. Depression and anxiety have never been higher. Now just think about this for a second. If you've got a device in your hand, 1 foot from your face, and 99% of the crap on that device is telling you how the world is going to end any second, right? We're all going to go up in a burning flame. There's climate change, and the old people are killing us. And there's LGBT, and the old people don't like us. And there's trans, and the old people don't like us. And now there's abortion, and the old people don't like us. And this is all you see all day long. Well, why wouldn't you be depressed and anxious? But the thing is, these are real people who we all live next to. So what we have to do is we have to find a way to have these conversations with them that hold in balance the truth of like what just happened, like the actual truth of what happened, and also hold in balance what the scripture teaches about life and about issues like abortion. Hold those things, and while you're holding those two things, then figure out how to juggle loving that person more than you love being right. Should be fun.